Thank you for everyone coming this afternoon. This is the fifth meeting of the Interim Joint Committee on State Government, and we've got a nice agenda here today. So, Madam Clerk, if you would call the roll, please.
Senator Alvarado.
Present in the room.
Senator Harper Angel.
Present remotely in the district.
Thank you. Senator McDaniel.
President, Mr. Chairman, it'd be great if everybody could go to mute, and I'm in the district.
Thank you. Senator McGarvey. Senator Nemes.
Present in the room.
Senator Schroeder.
Present in the district, thanks.
Thank you. Senator Southworth.
Present remotely.
Thank you. Senator Storm.
Present remotely in my district.
Thank you. Senator Thayer.
Here in the room.
Senator Wheeler.
Present in the room.
Representative Blanton.
Present in the room.
Representative Bowling.
Here in the room.
Representative Cantrell.
I'm present remotely. I'm in Louisville, but not in the district.
Thank you. Representative Decker.
Present in the room.
Representative Duplessis. Representative Fisher.
Present remotely in my district.
Thank you. Representative Flood.
Present in the district, and I would also ask that everyone check their mute button. Thank you.
Thank you. Representative Gooch.
Present in my district.
Thank you. Representative Graham.
Here in my district and in the room.
Representative Heath.
Present in the room.
Representative Heverin.
Present in the room.
Representative Imes.
Present in District 5.
Thank you. Representative Johnson.
Present remotely.
Thank you. Representative Cook.
Present remotely.
Thank you. Representative Derek Lewis.
Present remotely.
Thank you. Representative Scott Lewis.
Present remotely in the 14th district.
Thank you. Representative Maddox.
Present remotely.
Thank you. Representative Meeks. Representative Mentor.
Present remotely from the 20th district.
Thank you. Representative Moser.
Present in my district.
Thank you. Representative Nemes.
Present in the room.
Representative Scott.
Present in District 41.
Thank you. Representative Smith. Representative Stevenson.
Present in the district.
Thank you. Representative Tate.
Present in the district.
Thank you. Representative Tipton. Representative Upchurch.
Present in the room.
Representative Weber.
Present in the room.
Representative Wheatley.
Here in the room.
Representative Bratcher.
Here in the room.
Representative Miller.
Present in the room.
Senator Mills.
I'm here in the room. And as several has said online, we've got multiple members, so please check your mute button to make sure that you are muted and we don't get any background information or noise coming through. We have 2 days or two groups of minutes that we need to approve for the August 26th and September 1 meetings. Is there a motion to approve those minutes? We have a motion from Senator Wheeler.
Second.
Second from Senator Alvarado. All in favor, say aye. Aye. Okay.
Aye.
Minutes are approved. All right, our first item on our agenda is an overview of legislative immunity and legislative privilege. And today we have an expert with us online. His name is James F. Ted Booth, and you were given his presentation when you walked in the room today. That'll help you follow him. And Mr. Booth is is involved with, he's the general counsel for Peer in Mississippi. So he has studied this issue and is going to give us a good overview of legislative immunity and privilege. Mr. Booth, are you there?
Thank you, Chairman. Can you hear me?
Yes, we can hear you. The floor is yours, sir. Thank you.
Thank you, sir. As the chairman said, I am with the Joint Legislative Committee on Performance Evaluation and Expenditure Review in the state of Mississippi, otherwise known as the Peer Committee. We are the audit, evaluation, and investigative committee for the Mississippi legislature. We're a joint committee. We have 7 House members and 7 Senate members. I have been an employee of the peer committee for 37 years. So I've been doing this work for a long time. And for 23 and a half of those years, I've been the joint committee's general counsel. Also during that period of time, I have been the staff counsel for the Joint Reapportionment Committee. So I work on redistricting. In fact, I'm going into my 3rd redistricting as we speak. Glutton for punishment, you might say, but it's exciting work. And one thing about redistricting work over the years that I've been doing it, you come into contact with issues that we could result in our having to invoke or attempt to invoke legislative privilege in federal litigation. As those of you who are familiar with redistricting law know, that over the years, the courts have developed certain doctrines associated with racial gerrymandering, and some state courts have developed some doctrines related to partisan gerrymandering that require that the courts inquire into purpose and motive for drawing districts certain ways. And when individuals seek to discover information about such things, the possibility for invoking legislative privilege arises. Now, also in conjunction with my work for peer, I have dealt with lots of issues regarding confidentiality, whether it's confidential information held by state agencies or whether someone in the public or an interest group is attempting to access or gain access to information that we have here. Confidentiality is a second cousin of legislative privilege, if you will. They're very different, and we'll be talking about the differences as we proceed in this presentation. So I have considerable amount of familiarity with this subject matter, and with that introductory note out of the way, we're going to proceed. So what we're going to try to do in this presentation is cover the subjects, the questions, what is legislative privilege and what is legislative immunity? We're going to talk about the sources of privilege and immunity. We're going to talk about the availability of these in federal court, because once you go into a federal forum, things differ considerably. And then we're going to go over some general conclusions about legislative privilege and immunity. Now, what are legislative privilege and immunity? They're related doctrines. Legislative privilege simply is an evidentiary rule which, when it's successfully invoked, is going to protect a member of the legislature or a staff member from having to testify in a civil action or surrender documents when sought through discovery or subpoena. Legislative immunity, on the other hand, shields legislators from being civilly liable in certain instances. Now, these are related doctrines, and in fact, in many places, they trace their source to the same constitutional provision. Now, before we get into details on privilege, we need to talk about what is a privilege. Well, it's an evidentiary rule, as I said, with respect to legislative privilege, which protects a person from having to surrender documents or appear for discovery or to testify on a trial. Any one of you who is a lawyer knows something about privileges. And even if you're not, you've probably seen police procedurals dealing with priest-penitent privileges and attorney-client privileges. So you have a good feel for what a privilege is. Once a privilege can be successfully invoked, certain types of testimony are just off the table. Now, privileges are not really favored by our courts. In my state, for example, when you examine the Mississippi Rules of Evidence, which were promulgated by the Mississippi Supreme Court, in Mississippi, our court has the exclusive authority to declare rules of procedure and rules of evidence. The court says the privileges that exist in this state are those that are in our Constitution and those that are specifically in the rules. And the rules only name 4 privileges: attorney-client, interspousal privilege, priest-penitent privilege, and then the physician-patient privilege. That's it. Why are courts like this when it comes to privilege? Well, anytime somebody successfully invokes a privilege, they are holding outside of the litigation evidence that may be relevant and may be probative. And courts generally would like to go have before them all relevant information so that they can make a decision and search for what is the truth in this particular matter before them. So courts, as I say, if you can tell from our in Mississippi, they don't really like privileges. And I don't think we're too different from a lot of other states on that particular point. And privileges can be either absolute or qualified. And the concept of qualified privilege becomes rather important when we start talking about federal court. Now, what are the sources of legislative privilege? In your state, as in 43 other states, it's the Constitution. You all have a speech or debate clause in your Constitution, which protects you from having to testify on matters regarding things that go on in the session, and it also protects you from being arrested during the session. It's called a speech or debate clause. It's modeled on the one in the U.S. Constitution. 7 states, including my state, have no speech or debate clause. In these states, you're only going to be able to raise a privilege. Well, I should say the way to raise a privilege in our state is to invoke the tripartite system of government and argue that legislative privilege inheres in that sort of system of government. That's how they've done it in Florida. That's how they've done it in California, 2 states that have no speech or debate clause. Now, there are some problems with this approach, as we will talk about a little later when we talk about qualified privilege. But in these states, you really don't have quite as strong an argument. In some places, common law may actually be the source of a privilege. And in federal court, the courts have said the source of legislative privilege is federal common law. And once again, we will talk a little more about that in a little while. Now, we need to distinguish privilege from a couple of other concepts. One of them is confidentiality. I'm sure the Kentucky statutes are like the Mississippi Code in 1972. They're probably full of all kinds of code sections dealing with confidential information. You may have a code section that makes police investigative reports confidential. You probably have something that in force and effect that protects student records, health information. A variety of different things are going to be held confidential. Now, what that means is the person in possession of those documents is under a duty to protect them, not release them, particularly if a person comes in and makes a public records request, you have a defense to not releasing them. However, confidentiality in general does not shield you from the process of the court. If all you have is a confidentiality statute and the courts issue compulsory process for you to appear and bring your documents, generally speaking, that confidentiality statute is not going to shield you. Why? Because most courts have said a confidentiality statute does not create a privilege. Privilege is a much stronger concept. As I say, it's there to protect the documents from any kind of disclosure in court or any kind of administrative proceeding. So a confidentiality statute does not necessarily create a privilege. And because courts take a kind of a dim view of the creation of privilege, if somebody raises the argument that a confidentiality statute creates a privilege, the courts are going to look closely to determine, is there anything in the text of the statute creating the confidentiality of a document, any evidence to support the proposition that the legislature intended to create a privilege? And more often than not, they're going to say no to that sort of thing. Now, privilege distinguished from legislative immunity. As we said, privilege protects you from testifying and releasing documents. Immunity protects you from being a party and potentially liable. Now, legislative immunity in general, as I say, protects you from suit. Your speech or debate clause in your Constitution would provide you with some protection from being a party. In Mississippi, our legislators have to rely on a provision of our Tort Claims Act that we adopted several decades ago as a source of immunity. Immunity tends to be absolute and not qualified. If you are immune, you are immune. And immune from what? You're immune from suits that are brought against members in their personal and official capacity. However, it is very important that you remember that this immunity is generally available when someone is suing you for something that you did arising out of your carrying out your legislative responsibilities. The key is going to be, are they suing you over something that falls within the course and scope of your legislative responsibility? Immunity is also recognized in federal courts. There is a very important case, Tenney against Brandhoff, that was rendered by the U.S. Supreme Court in 1951, which is the federal source for state legislative immunity in federal proceedings. Briefly, Senator Tenney chaired a Tenney committee, as it was called, in the California Senate, which was investigating un-American activities back in the late 40s. And Brandhoff was somebody who was subpoenaed by the Tenney committee. Brandhoff brought suit under the forerunner of 42 U.S.C. 1983, deprivations of civil rights under color of law, and sought damages against Tenney. Well, it went all the way to the Supreme Court, and Justice Frankfurter, writing for the majority, held that Tenney and other legislators who were parties were immune in federal court. And Justice Frankfurter probably did the best job of anyone I can think of laying out the reasons why legislative immunity is important. And he said, when people are members of a legislature are carrying out functions that are essential to the legislative process, conducting hearings, collecting evidence, drafting legislation, considering legislation in committee, bringing legislation to the floor and floor debate, they're carrying out those essential functions of an arm of a democratic government. And the last thing we want them to have to do is face lawsuits for engaging in activities that someone may find offensive for some reason. Why do we care about that? Because if they have to face lawsuits, it could place a chill on your willingness to step forward and perform the legislative functions the way people in your state expect you to perform those functions. So Tenney is a great source document generally for understanding the policy behind legislative immunity and why we have it. Now, what is the source of this? Justice Frankfurter told us that something called federal common law is the source of this. Now, those of you who are lawyers might see the date on this and smirk. 1951, you might remember that 13 years earlier, in a famous case called Erie Railroad against Tompkins, the Supreme Court categorically stated there was no such thing as federal common law. Well, Justice Frankfurter rediscovered federal common law. This case is a strong case. It is cited often whenever the subject of immunity and privilege comes up in the course and scope of federal litigation. So it's an interesting case. Now, with respect to legislative privilege, its scope and application, I've got a few general statements to make. These are not jurisdiction specific. I think whenever you're thinking about a privilege issue in your state, you really need to consult with legislative counsel on this particular subject to determine just how the use of the privilege would play out in the state of Kentucky. Now, with that caveat, I'm going to proceed and give you some general principles that I have divined from doing research from all jurisdictions. One, a privilege if it's going to be invoked, it has to be invoked by the individual member. There were some cases coming out of Texas a few years ago when the attorney general and the governor and legislators were parties to some redistricting litigation, and the attorney general and the governor tried to invoke legislative privilege for all the legislators, and the court said, no, that's a privilege personal to the legislator. If the legislator for some reason doesn't want to invoke the privilege, you can't invoke it for that legislator. Now, the privilege can apply to staff as well as members. You all have close confidential working relationships with your staff. Those are important to carry out your functions. And your staff may be able to claim privilege in any litigation that might arise out of some legislative acts that you have carried out. So I would say this is very important for you to consult with your House counsel on this particular subject to see how far you can go in your state on this. Now, in some states, the privilege, unlike immunity, may not be absolute. In Florida, for example, where they had to conclude that privilege was a product, something that inhered in the structure of government in Florida from the tripartite system of government. They also said this had to be balanced against a strong policy in Florida about openness of records in government. So there was some balancing that had to be done, and the Florida courts ultimately concluded that certain activities of the legislature, particularly those related to conducting hearings and drafting legislation and introducing legislation and floor action, would be covered by privilege, but not others actions. And that's not an unusual position to take by the courts. But nonetheless, sometimes privileges are balanced and some are qualified and balanced, and sometimes they're absolute. Once again, consult with your House counsel on that. Now, another interesting thing, privilege can be waived through inconsistent behavior, delay, or policy. One should look at your public records law in Kentucky and find out how it is crafted. I believe you've had some litigation on this point in your state, if I'm not mistaken. I've always told people public records law and any kind of confidentiality provisions that might be in it for certain records probably can't create a privilege, but if it's crafted in a certain way, it could destroy an argument for privilege. If you make certain records open in an open records law, don't think that you can come back later and declare those things privileged and not subject to introduction into evidence if you have such a broad provision in your open records laws. Now, legislative privilege in federal courts. Once again, the case law follows two different streams in federal court. And as you might imagine, one of them says the privilege is absolute and one of them says the privilege is qualified. A distinguishing factor that a judge pointed out about 4 or 5 years ago in some redistricting litigation coming out of Virginia that I've never seen anywhere else, but it's a good rule of thumb. The judges argued that when the subject matter deals with private rights, for example, the chances are greater that the legislative privilege will be treated as absolute. When it deals with things that address important public policy issues, such as redistricting, expect the privilege to be balanced. The need for the privilege to not place a chill on the legislative process has to be balanced against very important federal policies regarding safeguards against racial gerrymandering and things like that. What sort of private interests might be the sorts that would be result in a conclusion that something is absolutely privileged? I've read a case one time on this particular subject, the one that immediately comes to mind, one that dealt with a challenge to a municipal ordinance in a beach community that barred mopeds. And somebody called in the city council and wanted to obtain discovery of the city council on why they passed this kind of ordinance. This is the sort of private interest in case where an absolute position on privilege might be accepted. But the kind of things that I deal with, particularly in redistricting, I don't expect any court to ever tell me that my privilege is absolute. Now, so once again, it is important to remember that these policies or I should say privileges in federal court may end up being subject to balancing. Now, there's some things related to privilege. There are a few federal circuits out there that haven't made much case law on the subject of privilege. I've noticed that in the 8th Circuit, they don't do much, but several of the districts have struck out on their own and have said that the deliberative process privilege, which is a qualified privilege that is discussed fully in various treatises on the federal rules of evidence, can apply to the legislative process. Once again, it's available to deal with issues that directly grow out of deliberation, conducting hearings, drafting legislation, committee action, and floor action. So in places where you haven't had a well-developed law of legislative privilege, you might be able to use the deliberative process privilege. Also, under the federal rules of civil procedure, there's the work product rule under FRCP Rule 26, which can provide some considerable protection for legal materials that a committee may have developed. Now, here's some general conclusions that I've drawn over studying privilege for a long, long time. The forum matters. If you're in federal court dealing with a very, very significant public policy issue, chances are your privilege is going to be qualified. And in redistricting cases, I'm afraid the federal courts usually find a way to pierce the privilege. In state courts, the critical question then becomes, what is the source of the privilege? In places like Kentucky, where you have a speech or debate clause, you're going to have a pretty strong argument regarding the absolute character of your privilege. If it's a common law privilege, maybe not so much. And in places like my state, where we have to argue that it's something that inheres in a tripartite system of government, might not be that strong. Remember, as I said a minute ago, the way you craft your open records law, that could easily defeat a claim of privilege. And remember that, once again, generally speaking, privilege arguments work best when you're trying to protect members from having to testify or surrender documents regarding the stages of drafting, conducting hearings, committee processes, and floor action on the subject of legislation or resolutions that you may be passing. Well, at this point, that takes us through this very general overview of privilege. If there are any questions, I'll be happy to entertain them.
Thank you, Mr. Booth. Are there any questions on the committee? This subject has been one that has been brought up by drafted legislation that David Mead, Representative Mead, had filed last year, and I thought it was important for us to get a grasp on it, especially us non-lawyers in the room. So, are there any questions for Mr. Booth? Mr. Booth, your knowledge is very well, very well in this area, and Representative Graham has a question for you.
Certainly.
Thank you. I'm not a lawyer, so it was kind of hard following you a little bit for those of us who are non-lawyers. The chairman is correct, but I want to go back to the last statement that you made, if I can.
Sure.
You said that maybe we would be able to invoke privilege with our open records law. Is that based on the changes that we made this
Actually,
session?
I would say that you need to carefully look at your open records law. You could craft an open records law in broad enough terms that it might actually defeat a claim of privilege. For example, if your open records law says that all materials associated with the preparation and drafting and consideration of the legislation are available, must be made available to the public and must be released upon a request, it's going to be hard for you to invoke legislative privilege in that case if your statutes pretty much say these records have to be open to everyone. So it actually works just the opposite way. Your open records law, and I don't know how it's crafted, could defeat that kind of claim. In our state, our open records law contains a section that says nothing herein shall be construed as limiting the legislature's power to determine access to its own records. And all joint committees like mine, my two committees, the peer committee and the joint reapportionment committee, have all adopted policies on that particular subject that make our work files confidential. Now, with the peer committee, since we're an audit and evaluation and investigating committee, certain things have to be public. Final reports that are voted out by the committee are released and made available to anyone on demand. In fact, we post them on the website. But all those other files that we keep, work paper files, interview notes, that kind of stuff is protected from public disclosure.
Thank you, Mr. Chairman.
Representative Wheatley has a question for you, Mr. Booth.
Certainly.
Thank you, Mr. Chairman, and thank you, Mr. Booth. We that attended a redistricting conference by the NCSL in Salt Lake City recently heard a presentation on legislative privilege, and it's great to hear that everything you've said comported pretty much with what we heard.
Well, I helped write the stuff that NCSL used, so it's a doggone good thing it did jive with what you heard.
Good. That's good, and it can be a complicated
yes, it is.
Set of rules to follow. And
it is.
We have something that's happened here in Kentucky that I think most of our committee members are familiar with. The Attorney General has issued some recent opinions related to the use of cell phones and what is discoverable or what is subject to our open records. And we heard some things out in Salt Lake City related to this issue, and the general advice is, treat everything as potentially discoverable. But in a federal case related to VR, the Voting Rights Act, would you give the same caution related to potential discoverable items that could be shared via text and via phone?
Yes, in fact, we have in several NCSL panel discussions over the years, we have counseled people to exercise quote unquote good email hygiene. And that would also be extended to text records that you might have out there. You just really need to be very, very careful in what you put into a text or an email, because as I said, in redistricting cases, there is a very, very, very good chance in federal court that the court will pierce the privilege and say the strong public policy need for having this information before the court outweighs any policy behind legislative privilege. So I would say be careful of what you put in your emails and your texts and anything else that could be recoverable.
All right. Thank you for that. And that kind of gets into the work product privilege too. And we know that you had presented that staff can call upon the work product privilege, but they also, in this case, or this scenario where it's a federal court involved, that means the staff could also be subject to the open records request or to the discoverable items. Is that true?
Yeah, that is true. Think of it this way: the privilege that a staff has flows from the privilege that the legislators have. I can't imagine a situation where a staff person's claim of privilege would be stronger than a member's. So if you're in federal court and the courts have decided that when they strike the balance in a redistricting case, the member is going to have to release his records, I don't think the staff is going to be protected more than the member will be. Anything's possible, but I don't think that's probable.
All right. Thank you.
Yes, sir.
Any other questions for Mr. Booth? Mr. Booth, I want to thank you for your presentation and for taking time to share your knowledge with us today. And,
thank you, Chairman. I enjoyed it.
Yes, and we are very grateful, and thank you for your involvement with the NCSL as well. So,
my pleasure. Thank you.
You're welcome. We will move on to our second part of the agenda, which is related to the future of remote working in state government. And Commissioner Mary Elizabeth Bailey, I believe, is online with us. Ms. Bailey?
Yes, I am here. Let me get my camera on and...
Very good. I've invited Ms. Bailey to share with us where state government is at on remote working. And at this point, I continue to be concerned about the customer service standpoint of state government and whether remote working is a positive or a negative for our constituents. And Ms. Bailey is here to present maybe some findings. Ms. Bailey, the floor is yours.
Okay, wonderful. Can you all hear me and see my screen?
Yes, we can.
Okay, fantastic. Good deal. Well, thank you all so much for inviting us to attend today and present on this subject. We are, in the midst of this new work model as far as giving agencies, forward here, choices for options for their positions. And what I want to do today is just explain what the options are that agencies have as far as setting up positions for work schedules. And as you are aware, and I previously testified to this as well, but on July 6th, agencies were told to, I'm sorry, I had an issue there with my screen. Okay. Agencies were given options for employees and positions within the executive branch. And those three options are that employees can be 100% in an office or a building. Employees can do a hybrid telecommuting schedule where they work both in an office or they work from a remote workstation, or they can telecommute 100%. And that means that, an employee is not working in an executive branch office or building, but they are working from a remote workstation. Now, these options going forward are to be reviewed quarterly by agencies. So the presentation, as far as the data that I'm going to show you today and the explanation, is based upon the numbers and what we looked like on July the 6th. We are going to be reevaluating this again in October. And so I'll move forward here. The first option, as far as work schedules that we have, work options, is the 100% in an executive branch building or office. Right now, we have 50% of the executive branch is working 5 days a week, or full-time, I should say, in our buildings or offices, or maybe they are positions like correctional officers or highway technicians with transportation, or they are inspectors of that nature. Those are a lot of the employees that fall into these categories. How to determine this? The positions that fall in this category are public facing, which means that they are not eligible to telecommute, or their job duties cannot be performed remotely. Or, we've had employees that had performance issues, and therefore, if they had scored in the previous two lowest categories with our performance evaluation system, or they're on a performance improvement plan, they are not eligible for telecommuting, because telecommuting is not a right. It is a benefit that we offer to our workforce. And so therefore, those employees are not eligible to telecommute. We also have employees at their request. They do not want to work remotely. They want to come in every day for, whatever reason, by their own choice. And so that is something that we are considering as well. When we get a request from an employee and they would like to work in an office or building, that we are taking that into consideration. Even though these employees are 100% in an office or building, they still have the ability to have flexible work schedules or compressed work schedule based upon, as long as if that is something that the agency offers. So they can still, like I said, flex their work day or compress their schedules within the week. The next option that agencies have when they are looking at positions is a hybrid approach for telecommuting. Right now, around 37% of the executive branch is on a hybrid work schedule. And that means that they telecommute anywhere from 1 to 4 days a week, that from a remote workstation. And one thing to note, is that telecommuting is not new. It was created over 22 years ago. It is authorized in regulation, both for classified and unclassified employees. It is not something that was just created by the pandemic, but it was something, obviously, that we had the ability to authorize and to increase that during the pandemic in order to keep our employees safe. And we did that, but it was not something that was just created in response to the pandemic. Many agencies, many employees and positions were telecommuting well prior to the pandemic and will continue to do so. However, with the pandemic, we did take a closer review of telecommuting in general across the executive branch, and we did create several things. One thing we did create was an executive branch telecommuting policy. This sets forth the policy and the procedures for the ability to telecommute. Agencies can all agencies must adhere to the baseline of what the policy requires, but agencies can also add additional agency-specific information to this policy. In addition to this, we have training that all supervisors and employees must complete prior to telecommuting. And so that they're, very, especially supervisors, it's very different to manage an employee that works remotely versus one that works in a brick and mortar building. It doesn't mean that it's not successful. It just does take a little more accommodations as far as when ensuring that you are communicating with that employee and ensuring that they are being productive and accountable, and that there is still, an open line of communication there. We also have a terms and conditions agreement that is signed by an employee, the employees, and the manager when they do, go on a telecommuting schedule. We have a safety checklist that we ensure that the employees' surroundings are of a safe nature. And we have the ability in the telecommuting regulation to that the agency can visit the employee's remote work site at any moment with or without notice. So that is something, to ensure that that it is a safe environment where the employee is working. And even though the employee is telecommuting, they are still eligible for flexible work schedules. So they can still work, like I said, a flexible work schedule or compressed work schedule. So there are several options, even though that they are telecommuting. And then our last option, as far as a work model that agencies have, is 100% telecommuting. And right now we have around 13% of the executive branch. So that is a relatively small number that telecommutes 100% of the time. And that means their full-time schedule is working remotely. Again, this has been historically authorized in our classified and unclassified regulation. The difference between this and the hybrid schedule that I just talked about is that it does require the approval of the personnel cabinet. Either the secretary or myself do review those requests from an agency if an agency is wanting a function or an organizational structure to telecommute 100% of the time, then they must send a request to the personnel cabinet for approval. In doing so, in order to determine whether or not a position is eligible for telecommuting, we created a criteria document, and that just goes over many things from to help the agency make a determination whether or not this would be a good fit for this position. And it goes over things from, is the knowledge that's required in this position, is it something that, they would need to be on site to work with other employees in order to do their job? Is it something that, is it public facing? Is there specialized equipment that they might need that would prohibit them from working remotely? Is it a position that requires travel or task scheduling or any type of secured information? All of these things, plus other factors, go into, the criteria consideration for determining position eligibility for telecommuting. And then again, we have the policy that sets forth, and then the required training and the terms and conditions and the safety checklist. And even though employees, if they are approved to work 100% telecommute, they can still be allowed to, again, do the flexible work schedules or a compressed work week. So we have several options that are available now for agencies when they are establishing positions or reviewing their workforce. We have, over the last year and a half, we have, evaluated our workforce significantly, especially when it comes to recruitment and retention. This is a significant tool that we are using to try to continue to be competitive with the private sector. And as we've seen, there's plenty of major companies that are telecommuting and are going to continue to do that in the future. And there's not, as long as we are continuing to meet the needs of the citizens of the Commonwealth, which I think that we have proved and have been able to do that successfully. I do not see, especially since this has historically been authorized and we've been doing this, I don't see this changing in the future. I think this was something that, these type of options will be something that will be available to agencies in the future.
Very good.
Yes.
Commissioner, we have a couple questions in the queue. Representative Nemeth has a question.
Thank you, Mr. Chairman. I want to thank the presenters. I think this was really a good presentation and eye-opening for me. I talked to a lot of businesses in my district, and COVID has brought a lot of very negative things, obviously. But one of the things that it has brought is the opportunity for efficiencies and cost controls. I see that 2 out of every 5 of our executive branch employees in Kentucky are not coming to work in the office place. They're going to remote work, and I assume that's mostly at their home. So I think it would be beneficial to know whether there can be some opportunities here for cost controls. So what I would like to request from the executive branch is, in each of our areas of the budget, I know this is an A&R question as much as it is a state government question, but we divide our budget into 7 subcommittees. I'd like for each of those subcommittees to get a list of all of the employees who are telecommuting is in their area, why there is no need for them to come to the workplace, and that it's efficient for them to work from home, which is a good thing. Also, whether those jobs can be reduced, reducing the burden on the taxpayer, obviously for these workers. If they're necessary, great. If they're not, then let's take a look at this. Let's take COVID as an opportunity to take a look and see if we can further reduce our personnel roles. And then also, I'd like to know if we can have rent reductions since these folks aren't coming to work at the workplace in Frankfort. 2 out of 5 was a very high number. I thought it would be, I thought it'd be in the teens. But I think the taxpayer would be very interested to know that 2 out of 5 executive branch employees are not coming to the office. And so I'd like the information that I've requested. And I think the best way to get it would be perhaps to send it to the subcommittee so they could use it as part of the budget proposal that we'll have in the near future. So thank you, Mr. Chairman.
Thank you. Senator Thayer.
Thank you, Commissioner. I've had some complaints from people who have tried to have contact with various front-facing agencies that provide customer service to constituents, and partially because they can't reach people because they're working from home. What's the remedy to this, and how soon before we can get these people back to work in the offices that the taxpayers of Kentucky have paid a lot of money over the years to construct?
Well, any complaint that you have received, if you can send those to me, we will definitely look into those. Our forward-facing agencies, first of all, the executive branch has not stopped working through the pandemic. We have continued to work every single day, and many of our areas have worked even harder throughout the pandemic. Our forward-facing agencies, they are all, as far as public-facing, for sure, they are in the buildings. They are working. They are providing services to the Commonwealth, to citizens. So I'm not aware of any issue. So if you can send those to me, I'd be happy to look into those.
Can I follow up, Mr. Chairman?
Yes, you may.
Thank you. Commissioner, I didn't say that people weren't working.
Yes.
You've just pointed out yourself that 30% of the workforce is not working off 40%. Thank you, Representative Duplessis. Didn't say they weren't working, but I think especially if they're in the customer service areas, and we all know about the debacle with unemployment insurance, they're working from home, and if people are trying to get in touch with them, it's just not as efficient. We need to get these people back to work in their offices. Thank you. And if I do have any more complaints, I'll be certain to forward them to you personally.
Okay, that'd be great. Thank you.
Representative Bowling.
Thank you, Mr. Chairman. Thank you, Ms. Bailey, for this presentation. My question is on these policies. Are they the same for all employees? And the reason I asked the question is I'm a border county. I live a mile from Tennessee, a mile from Virginia. And some employees there have informed me that there's one policy if you are a resident of Kentucky, and then there's other policies if you live out of state. And if that is the case, why so?
Employees that live out of state, they are required to work in Kentucky. They cannot telecommute from their state if it's outside Kentucky, and that is for various reasons, for taxes, for various employment requirements that we would be required to adhere to based upon that state, and they are employees of the Commonwealth, so they are required to work in Kentucky.
Okay, but they have not been. They still aren't as of today, but they will be. So that change has happened recently. That's not been the blanket approach throughout this thing. So that's changed recently. What are the reasons for those changes?
For those reasons, at the beginning of the pandemic, there was some leeway federally with that, but that is something that's no longer the case, and employees will not be able to telecommute outside of Kentucky.
Thank you very much.
Thank you.
Senator Alvarado.
Thank you, Mr. Chairman. Thank you, Commissioner. We just heard a presentation on legislative privilege right before your presentation, and had a warning about being careful what you text and what you email. I'm curious, if people are telecommuting, are they using government computers? Are they using personal computers to do their work?
No, the government computers.
I would have to defer to each individual agency for that response.
So are you saying that there might be some agencies that are permitting people to use personal devices to perform their work, state work?
Probably so. I'm not 100% sure on that.
We just heard information about all that information potentially being discoverable if there's any issues. Are employees aware that if they're using personal phones or personal devices, that this could be subject to being discoverable, and all the information on those devices being discoverable?
That is something that we can definitely remind employees of, that information for sure.
Yeah, I mean, if you have 40% of your workforce currently doing that and they're using it from personal devices, and I know you kind of mentioned there your terms and conditions for doing that might be something to put in there. I mean, if you have employees thinking, hey, I'm doing work and I've got whatever they're researching on their computers suddenly discoverable if there's a lawsuit or there's some issue within the federal court system or the state court system, and it could be discoverable, particularly with the executive branch, I think that's a major concern, don't you? I mean, I'm wondering if our executive branch hasn't taken that into consideration. That would be something you probably need to make sure you take care of for a lot of our employees.
Yes, and in the policy, we have a confidential and sensitive information section. We have an equipment section. We have a maintenance section. We talk about state-owned equipment, employee-owned equipment, various things like that. And I'm happy to provide the policy to you all to review if you would like that.
That'd be great. I think it'd be most important, at least for, again, if folks are using home devices, to know that any information they have on there, those can be confiscated and probably researched by somebody. And so I think I want to make sure that's important. That's something that's available that our employees know, because they might think that that's protected. So that would be probably something good. I'm not sure if it's in your terms and conditions agreement that you have with the state employees, but I think that'd be worthwhile knowing. Or if we're going to have this as being something routine, that they can use a government device to do all their work on, just because otherwise I think anything will have to be tracked on those personal devices. Thank you, Mr. Chairman.
Yes, absolutely. Thank you so much.
Senator Wheeler.
Thank you, Mr. Chairman. Yes, Commissioner, I guess my question goes along a little bit with some of the points that Senator Thayer made. Do you have any metrics that you're using to judge the comparative efficiencies of the employees who are working from home versus those who are actually in the office and in person, to see, I guess, for lack of a better term, whether or not the Commonwealth is getting their bang for their buck by utilizing these programs?
Those specific metrics are at the discretion or tracked by each individual agency. when they look at their, work productivity and accountability on how that is part of the requirement from the executive branch is that each of the agencies are tracking that. So that is something that I would have to defer to each agency to be able to provide.
Okay. Mr. Chairman, if I could have a brief follow-up.
Yes, you may.
Okay, so if, for example, one of the employees that is utilizing these privileges to work from home is, not meeting performance standards, I mean, are they being compelled to come back into the office environment to account for that?
Yes, absolutely. And that's part of the policy and the terms and conditions. First of all, an agency can cancel the telecommuting agreement at any time for any reason. And definitely for a low performer, as soon as that is something that is realized, then that employee will immediately return back to the office.
Okay, and do you know how often that they're actually measuring these performance standards, the individual agencies?
No, that's definitely, that differs based upon the agency or the position, the job classification. That is something that I will also be reviewing when we do the review in October, asking some general questions around that. But it really just depends on the specific job.
And I guess, and finally, if I might be permitted one more, Mr. Chairman.
Sure.
To what extent are these privileges being utilized more so in urban areas? Because I know coming from a rural area, some of our IT services aren't quite as good as what they have in the more our state. Are essentially the folks in the urban areas allowed to utilize telecommuting more so than folks from out in the country like me?
I would not say. We probably have more employees in urban areas that just employees in general, specifically in, I wouldn't say that there's more that is really going to differ by agency. But if you all, if you would like to receive any type of work county information, we'd be happy to provide that.
Thank you, Mr. Chairman. Thank you, Commissioner.
You're welcome.
Thank you. Co-Chair Miller has a question.
Thank you, Mr. Chairman. Commissioner, just a little aside from Representative Nemes's question. For all these people that are able to work from home, are you allowing them to opt out of paying occupational taxes in Franklin County and being taxed in their local community?
It's not so much opt out. Occupational tax is paid based upon where the employee works. So even if for those employees that are working a hybrid model, however many days that they are in whichever county, that is how that it is taxed based upon that. So if they're 2 days in Franklin County, then they'll have 2 days of the occupational tax in Frankfurt, and then 3 days in the county in which they are working remotely.
Follow up, please.
Yes, you may.
Commissioner, having worked for state government many years ago for 4 years, I find that a little surprising. So if an employee says, I'm paying Franklin County tax and I shouldn't be, who do they go to?
Their HR office.
Very good.
Yes.
Thank you. I hope everybody heard that.
Our final question is Representative Graham.
Thank you, Mr. Chairman, but the Senator Wheeler asked most of those questions, but I would go back to what the senator from Scott County said. I would like to see people back in their offices working to resolve the issues. And from my standpoint, I think these issues can be resolved quickly with people being in the same office to go and contact those who have the experts in the question that needs to be answered. And so if we're going to be efficient and proficient, it is better for our members or our employees to be within the confines of the building so that they can provide those who are working on the front line with the information that they need to carry out to our citizens. And this is the seat of state government. And from our standpoint, the Chairman Miller, and we want people to pay their occupational taxes wherever they're working. But we also, from my standpoint and from representing Franklin County, we have lost income. But that's not the issue, although it is the issue for our local government. The issue is being proficient and efficient in providing the services that our people of the Commonwealth are paying for. So thank you, Mr. Chairman.
Good. Senator Thayer.
Thank you, Mr. Chairman. I would like to cheerfully note for the record that Representative Graham and I are in full agreement. And further,
do we need to get the photographer?
Further, I feel like I've woken up in a strange parallel universe, but I kind of like it.
The rest of us are afraid of the lightning.
It is a bit frightening, but I'd also like to say that Representative Graham spoke more eloquently than I did as to why we need to get state employees back to work in their offices. Now, it's a different deal altogether if they are consultants. That's a different deal. But employees should be in their offices. And there's no reason, with everything we know about COVID, that it cannot be managed appropriately, especially in these front-facing jobs. And of course, the other fact that was brought up by Representative Miller and Representative Graham regarding local occupational taxes, that's a really big deal. So, Representative Graham, who I respect and have worked well with over the years, we don't often agree. We disagree agreeably from time to time. And this was an important thing, and I wanted to make sure I noted it for the record. And I respect you, sir, for your position.
All right. Thank you so much. We've had a lot of participation, and Commissioner Bailey, thank you for your comments and the presentation today. If there are no other things to be brought before the committee, our next meeting will be October the 19th. So is there a motion to adjourn? All right. We are adjourned. Thank you.